Good evening to everybody. Welcome to the class of the Muslim law for those who are going to appear for the examination on 6th December 225. And that is the PG college, if I may not be mistaken, in Khammam. Yes, now you can see that what I posted here, the same thing which I posted to you in the morning. There is a dissolution of marriage. And can anyone read? Please unmute and read.
Sir, dissolution of marriage by act of God, death of a husband or wife, by act of parties divorce, by act of parties divorce, judicial divorce by wife under the Dissolution of Muslim Marriage Act 1939. This side, extrajudicial divorce. Extrajudicial divorce is by husband, talaq, to
Ila.
jihar, sir. Ila, jihar. By wife,
Jihar.
delegated, sir. Jihar. My wife delegated talaq by mutual agreement, Hula Mubarak.
Yes, this is the dissolution of marriage. Dissolution of marriage is nothing but the divorce. I repeat, dissolution of marriage is nothing but divorce. Sir, what is the difference between a divorce and a talaq? Anyone? Whatever is that you know, please tell me. Doesn't matter. If it is wrong also, no. There is no minus marks. If you don't know, you say pass on. If you don't know, you say
Talaq?
pass on.
Sir, pass on, sir.
Yes. See, when it is done through the judiciary by act, enactment, we can say it is a divorce. But when it is done or operated by the personal law, Muslim personal law, then we can say it is a talaq. So talaq is a extrajudicial divorce. See, it is here and here. Talaq is extrajudicial divorce. That's why you can say by the husband, by the wife, by mutual agreement. By the husband, it is a talaq. Again, there is the two types of talaq. Talaq-e-ahsan, talaq-e-ihsan, then talaq-e-biddat. There are three types are there, not two types. Then ila is there and jihar is there. From the wife's side, there is a delegated talaq would be there. For the mutual agreement, we can say that hula and mubarat. This is one slide that I would like to show you. Then another slide which I want to make you is here. Yes, this is another side where the classification of the dissolution of marriage. I repeat, classification of the dissolution of marriage, which is nothing but divorce. So divorce can be made by the two ways. Number one, the left-hand side, by the death of a party, divorce will come automatically. Then the number two, the right hand, we can say by divorce. When you say by divorce, again it is divided into the four. Number one, by husband. Number two, by wife. Number three, by mutual consent. Number four, by judicial decree under the Dissolution of Muslim Marriage Act. And this is the right one, is the divorce, actually, which is done through the enactment. But the right 1, 2, 3 is a personal law, Muslim personal law, which is nothing but the extrajudicial. And again, the husband, we can say, husband can give the talaq or ila or jihar. And the wife can give talaqil tafweez, that is delegated by the husband. What is delegated by the husband? Giving the talaq is delegated by the husband to the wife. Then mutual consent, okay, in the form of the khula or we can form of the mubarak. Then when you come to the judicial decree under the Dissolution of the Muslim Marriage Act of 1939, there is a liyan and fasq. These are the two things are there. Again, I told you that talaq are two types are there. Not two types, there are three types are there. One is talaqul sunnat, where it is subdivided into the talaqul ahsan, A-H-S-A-N. Then second one is talaqul hasan, H-A-S-A-N. Then talaqul biddat, there it is a form of the written talaq or orally saying T-A-L-A-Q, 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 because I am also not supposed to pronounce it. So it is a triple talaq which is said to be unconstitutional. Which case law the Supreme Court has decided the triple talaq is unconstitutional. It is contravention with the Article 14 and the rest of the article, including the 21. Can anyone give the name of the case law? If you don't know, you say pass on. If you know, you can give me the answer. Yes. If you know the answer, you can give me the answer, name of the case law. If you don't know, you say pass on. I will give the answer instead of wasting the time.
Sir, Shabanu, sir.
No, Shabanu is a maintenance case. Even after the iddat also, a husband could have to maintain it. That according to the, as per the CRPC 125 section is concerned. That Sayara Bano versus Union of India. See, here I will show you the thing where you can easily make it out, which I am going to. Yes, can anyone read? Unmute and read what I put on the screen. Yes. Can anyone
Sir,
unmute
what are
and
the
read?
Sir, what are the three types of talaq?
Yes.
Sir, Sir, namaskar, assalamu alaikum. Good
Okay,
morning.
forget about that one. What are the three types of the talaq?
Okay, sir. Talaq is also the three kinds. Talaq Hassans, Talaq Hassan,
Yeah,
and
Hassan.
Talaq, sir, Hassan, and Talaq Biddat. The Quran and Hiddat
Hadith.
sir, 1 second, sir. Hadith, sir. Hadith sayings of the Prophet
Muhammad.
Muhammad, sir,
That is it.
Muhammad PBUH.
That peace be upon him.
Yes, sir. Approve of Talaq, Hassan and Talaq Hassan as they are considered most reasonable form of divorce in Islamic law. But Talaq Ibidat triple Talaq is neither recognized by the Quran nor by Hiddat.
Hadith.
Hiddat, sir, Hajit. Sir, triple talaq is unconstitutional as they violated the fundamental rights of women and enshrined in articles 14, 15, 21 and 25 of the Indian Constitution was decided in the case of Sahara Banu, sir, Saira Banu versus Union of India.
Not Saira Banu. Shayara Banu. Shayara.
Okay, sir.
Shayara. Shayara space Banu.
Okay, sir.
ANO versus Union of India. AR 2017. 9th page Supreme Court cases. And it is given in that citation. So that is the case law where we can say Sayara Bano versus Union of India. That case law could be used over there, and that was the thing. Then let us see the introduction. What is the introduction which is given over there? Before we are going to make it the divorce, first we have to know the marriage. How could the divorce would be there without the marriage, please? Anyone? No divorce when there is no valid marriage. So that is the point. So different religions define the marriage differently, such as according to the Hindu Marriage Act 1955, marriage is a religious sacrament. And regarding the Muslim law, also say the marriage is a sacrosanct. But Justice Mahmood said that marriage is a contractual obligation. That he said. But in some cases, it is very much clear that it is a combination of both. Let us see that under Muslim law, marriage is a contractual relationship between the two parties. All the essentials that are required for a contract are present under the Muslim marriage. There is an offer, acceptance, consent, consideration, the capacity of the parties, etc., which are the essential elements for the contract. That element should be present. The purpose of such a form of marriage is two things. Why the marriage is made in such a manner? Number one, legalizing the BBC, that is the sexual intercourse, and number two, procreation of the children. These are the things. So in the case of Shoharat Singh versus Jafri Begum, I repeat, Shoharat Singh versus Jafri Begum, the Privy Council held that the marriage under the Muslim law is a religious ceremony. But Justice Mahmood said, is the marriage is a contract. Under Islam, marriage is recognized as a basis of society. Marriage is an institution which leads upliftment of man, and is also a means of the continuance of the human race. So that is the purpose of the marriage, why the marriage should be there. Sir, marriage la brass band and do sir. Why the marriage? There would be a music, there is a brass band, there is a lot of noise. Can anybody give me the answer? If you don't know, you say pass on. If you don't know, you can say pass on.
I think so. It is a custom, sir.
It is a custom, number one. People should have to know that they are the wife and husband. So it is in the indirect way informing the other people that they are got married. Now they are the legalized to have a BBC and procreation of the children. That is the meaning. So divorce now, no, after the marriage is over there, then the question comes next step is, I don't say divorce, no. Divorce is the last resort. Perhaps we should not supposed to do like that. Divorce is the end of such a marital relationship. As under the Muslim law, there are two modes are given in the dissolution of marriage. One is divorce and another is talaq. As I told you already that divorce by the judicially and the talaq by the personal law. In a daily life, those two terms are alternately used, but under the Muslim law, if a person seeks divorce, he will be governed by the provision of the Dissolution of the Muslim Marriage Act of 1939, means enacted law. And whereas talaq proceedings are governed by the Muslim personal law. There's a source of Muslim law. Quran, Hadith, Ijma, Qiyas, secondary sources, which I dealt in the last class, the four that also considered. Now let us see the classification of dissolution of marriage. If the table already have shown you the table, the classification already also shown like this classification. Is it not? If you want, we can take the screenshot also, this classification. Otherwise, anyway, that is, I am loading it on YouTube today, the class, and perhaps it will not be, the current will not go now. In that presumption, and I am doing so. So, talaq is a proceedings are governed by the personal law, Muslim personal law. Then classification of the dissolution of marriage, about will clearly says over there. Let us see from the by husband side. But already, as I told you, that by death, divorce should be there. By the parties, the divorce should be there. And here, by husband, how the divorce could be taken place, let us see. There are four modes available before the husband for dissolving the tie of the marriage. Number one, talaq ul sunnat. This form of talaq is effective in accordance with the tradition established with the Prophet. It is further divided into two parts, but is talaqul ahsan, A-H-S-A-N. This is one. Another is talaqul hasan, H-A-S-A-N. But let us see the A-H-S-A-N, ahsan. It is known as the best form of talaq, as the name clarifies the same. The procedure followed by the husband is as follows, because this is by the husband side. What are the procedures should be followed over here? Let us see that. Number one, he has to make the pronouncement of divorce, that is a TALAQ, in a single sentence, such as a pronouncement must be made in a purity state. Whose purity state? Wife purity state. What is the wife purity state? When a woman is free from her menstrual cycle, at the time we can say purity state. Other way we can also say as a another terminology also there. Can anyone tell me what is the another terminology where we can say pure state or purity state? If you know, you tell me. If you don't know, you say pass on. Yes? If you know, you can tell me. If you don't know, you can say pass on. Don't waste the time.
Sir, pass on, sir.
Tuhur, T-U-H-R, tuhur means purity state. Tuhur, that's the purity state, where a woman can be conceived if she is having the BBC with the husband. Okay, second point is, a husband must not indulge in any form of sexual intercourse during that period. That is the period of chastity of a woman is bound to observe after the dissolution of marriage, either by the death of her husband or by the divorce. And if he does so, then it will be considered as implied revocation of the law. Suppose in that period, it depends upon the death or it depends upon the divorce, and that period would be there generally 3 lunar months. If the death is there, we can observe how many days? 4 months, 10 days. Am I right? Am I right?
Yes.
Sir, we don't know.
Yes, sir. I know, sir.
See, death is, that period is different. Divorce is, that period is different. Please note the point. Okay, it is pertinent to note that once the iddat period has expired, the divorce become irrevocable. Suppose here in the point, no, only one time he will say in the three three period of tuhur, purity state means 1 month, one period of tuhur. Only one time he will say. What he say? TALAQ. That's all. In the second month, he will not say. He will observe abstinence, means no BBC, no what I say, sexual intercourse with the wife. The second month, purity state. Third month also, he will abstinent, not having the sexual intercourse with the wife in the 3 months, mean 3 purity periods. Then automatically it is irrevocable, means it is sanctioned and it is a talaq. That's why when the partners have not consummated, see here I made it. When the partners have not consummated, talaq-e-ahsan can be pronounced if the wife is in her menstruation. Even the third time also she is in menstruation also doesn't matter. But generally, 3 times observation of the purity period would be considered. In the 3 months also, he will not have any sexual intercourse with the wife. Then once the 3 month purity period is over, then automatically it is irrevocable, which is talaq al-ahsan. But only one point I want to make it clear. Only one time he will say TALAQ. That's all. In the first month. Second month he will not say, but observe no consummation. Third month, no consummation. That is the point. That is the ahsan. Because such a bad word should not be taken on the mouth, on the tongue. That is actually the reason. Hasan, Talaqul Hasan. Here the Arabic meaning of the Hasan is good. Therefore, divorce pronounced through the Hasan mode is good, but lesser worth than the one pronounced in the Hasan. Husband has to make 3 consecutive pronouncement for the divorce. First month, TALAQ. Second month, purity Tuhur. Again, TALAQ. Third month, again the purity period, TALAQ. He has to pronounce it. Means he has to utter the word TALAQ 3 times, such a bad word, which the Prophet himself disagree, because that is the last resort. So that is called Hasam. In the case of the menstruation wife, such 3 pronouncements should be made in 3 consecutive to her. In the case of a menstruation wife, suppose menstruating wife is not, menopause is there, just you count the 30 days. In the case of non-menstruating wife, that is menopause, pronouncement should be made all the 3 consecutive intervals of the 30 days. That we can say. But one thing, no sexual intercourse should take place during this period of the 3 pronouncement if such an act takes place. Suppose if any intercourse takes place, BBC take place, consummation will be the partner, then the process of divorce will be revoked. Automatically, it will be revoked. Of course, again, the talaq al-hasan becomes irrevocable on the 3rd pronouncement, irrespective of the period. Of course, once the period is over, there 3 pronouncements are there, it is then after that it becomes irrevocable. That is the talaqul hasan, ahsan, AHSAN, and talaqul hasan, HASAN. But the last one is the second, another category, talaqul biddat. For the biddat, even the Umayyad dynasty, it was there. This is a sinful form of talaq. It is recognized among the Hanafis. Sunni law recognize this mode of talaq, though recognized as sinful by the two, whereas Shia and Malikis don't recognize this mode. Only Sunni they recognize. I already told you this regarding why at the time Umayyad period was there. Because it's the expansion of Islam would be there. People, conquered Syria, Egypt, Morocco, and other places. But if you happen to see the Syrian woman and Egyptian woman, and they are so beautiful that these people would like to lure her because their husbands are died, no more there, no more anyone to take care of them. That's why they used to give the triple talaq to the existing one. They want to marry them. One way, either for the sake of the sex, another way for taking care of them. Perhaps that is the mode, but Prophet did not recognize it because it has happened only the 3rd dynasty, that is Umayyad dynasty, it is happened over there. Now let us see 3 pronouncements made in a single tuhar, either in a single sentence or a separate sentence. TALAQ, 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 or IDIVORSE, THET, or IDODIVORSE, then IDIVORCE, Even I don't want to also pronounce it because it seems that I am also uttering such a word. Bad. So, single pronouncement clearly indicates an intention to dissolve the marriage, make it irrevocable. It is usually pronounced as a IDIVORCE, irrevocably. That's why Talaqul Biddat is unconstitutional. It is merited. Even Prophet himself also will not agree to the Talaqul Biddat. Partners separated through the triple talaq cannot remarry without the formality of the woman marrying the other man, getting for divorce from him. This process is called nikah halal. Yes. Suppose if you once you have given the talaq to the woman, if you want to marry the same woman, no, you cannot marry unless until she has to marry to the another man, have the sexual intercourse with her, later iddat period, divorce her, iddat period should be observed. Later on, he can marry again the same person to who has given the divorce. That is called nikah halal. So in the recent judgment, I already told you that Shayara Bano, Shayara, Shayara Bano versus Union of India and others, Supreme Court of India declared that the practice of the triple talaq is unconstitutional, as it made 14, 15, 25, 19, 21, 25 articles of the Constitution of India. That is one of it. That is talaq. Then ilah, vow of continuance. What is ilah? The situation where the husband who is the sound mind has attained the age of the majority swears in the name of God that he will not have a sexual intercourse with your wife. He voluntarily doesn't have the sexual intercourse with his wife and leaves her to observe the iddat period and leave her observe the iddat period. At the time, abstinence should be there, continence should be there, sexual intercourse he doesn't have it, and he said to make ilah. That is called the ilah. And if the husband resumes the sexual intercourse within the iddat period being observed by the wife, it will lead to the cancellation of ilah. It is pertinent to note that the ilah is not a practice in India. It is nothing but not having the BBC with the wife. Such a pertinence would be there for that period. But generally, nobody would follow in India, this ilah. In the same manner, jihar, there is the injurious assimilation. The jihar, a husband must be of sound mind and above the age of 18 years to be eligible to use this mode of dissolution of marriage. If he compares his wife to his mother, he say, mother, amma, akka, chelle. Can anybody will say a wife as a amma, akka, sir, love and affection to Jepachka, sir, amma ani? Yes, what is your opinion? What is your opinion?
Yes, sir.
But preferably they say, don't say, yeah, okay, you can say darling, you can say oxygen, you can say my better off, you can say my lovely, you can say any other, my rose. Are you following me?
Yes, sir.
Yeah, with the nickname, suppose it's so beautiful, we can say dream girl. Are you following me?
Yes, sir.
Yes. So better you try to avoid it. Please don't call. You call with love and affection with my gold, you can say. So calling the wife as a mother or a sister or a female within a prohibited degree is called jihad. The wife has a right to refuse to have a sexual intercourse with him. Such a refusal can be accepted until he has expiated himself from the penance prescribed by law. So suppose if he says so, of course, the repentance also there. If you repent it, like repentance means offering the food for the 60 hungry man or observing the fast for 2 or 3 months, that is another form of the penance, we can take it back. So muta marriage practiced among the Shias, which admits to other sort of divorce, may be dissolved by the jihad. Of course, muta marriage is a temporary marriage because it's a time-bound marriage will be there. Naturally, they don't have such a thing. Later on, they will wind it up. Of course, this also jihad also no more in a practice in India. And then we'll say talaq by the wife. How a talaq by the wife? Talaq by the wife will be given under the husband delegated power. What power? Talaq-e tafweez. Talaq-e tafweez. This is the only way through which a woman can give the divorce to his husband. Again, the question comes: what are the conditions should be fulfilled? In case of the husband marries a second wife, he can say that, okay, I am giving the permission to you to give the talaq al-tafweez. The husband is unable to maintain her for a specified period of time, any other condition that must not be opposed to public policy. At that time also he can. Suppose if you sexually will not satisfy that woman also, perhaps because she is old or she doesn't have the interest, or there is a stranger relationship within her, Any other such a cause would be there, the husband will delegate the power to the wife to give the talaq. If the condition agreed to the agreement by the husband as well, practiced by him, then wife without any prejudice to law can dissolve her marital ties. Then wife if agrees over there, then marital ties will be dissolved over there. The fact that the husband delegates the power, the husband delegates the power to the wife, does not disposes him of the right to pronounce talaq. Suppose if he has delegated such a power, it doesn't mean that he doesn't have any power to give the talaq. No, that the power still he retains it if he wants. So that is the one way. The divorce by mutual consent, that is self-explanatory. Both the wife and husband agree together. Of course, earlier in the Muslim law, there is no such a practice in personal law, but only after the Dissolution of Muslim Marriage Act of 1939, this mutual consent is inserted over there. By that, a divorce can be given by the court. Of course, they don't give so much easily. They will say that they will say, observe at least 6 months after the decree. Because there may be possibility that they will be reunion would be there, or means unity would be there, or reconciliation would be there. So that is the point. Because the last resort, even by the court also say, talaq is not the good way, divorce is not the good way, but last resort they will say reconciliation would be there, so that the house will be a house, their constructive house, other their life becomes miserable if they do have the children. So that is the no fault of them, the children become the victims over there. Then another form of is khula. Yeah, khula means it is moved from the wife's side. The literal meaning of khula is to lay down before the law. The husband lays down his right over his wife. It signifies an arrangement entered into the the connubial connection in lieu of the compensation paid by the wife. Suppose the husband says, "You give me this much amount to you, I will give the permission for the khula." So you can have a right to dissolve the marriage and get married to another person. So the wife to her husband out of her property, suppose he will give some amount of her property to the husband, and everything can be given as a dower. So he will say that everything that can be given as a dower to me, I will return back to you, plus some additional amount also to you. And that form of the divorce is, or talaq is, hula, means untying the bond, to lay down that, the permission will be given. But it is moved from the wife's side, not from the husband's side. But the mutual consent is moved from the both the side. Of course, there is another Mubarat also, there we will come across Mubarat, what it says. So in the essentials of the khula is concerned, there must be an offer from the wife's side. I already told you. There must be an offer from the wife's side. Wife says that I will give some amount to you. Dower including the capital, its interest or some other thing to you, but you make me free so that I could marry to another person. Number two, offer must be accepted by the husband, which the consideration for it. That again should be offer, that acceptance should be there by the husband. If he's not happy by that one, then he say there is no khula possible. The third condition is that observance of the iddat period is necessary. Yes, 3 months they have to wait. 3 lunar months. I already told you. 3 lunar months. Under the Shia law, husband cannot revoke the divorce once accepted, where the wife has been given the power to reclaim the consideration during the death period. At the time, of course, in the Shia law, they say husband cannot revoke the divorce once accepted. The wife has been given the power to reclaim. Yes, she can have the right during the death period also, that reclaim the consideration during the death period. Why during the death period? Even after the death period, no. After the death period, he could not get it, because it is a mutual consent by the two parties, especially the offer from the wife or the acceptance of the husband. At that instance, up to the death period only, that consideration will be paid. Later on, it will not be paid. Okay. Now let us see the Mubarak. What is Mubarak? It is a mutual discharge from the marital tie. The most essential element that the mutual consent of both the partners are required in regards to the dissolution of marriage. Means husband also willing to give the such a consent, even a wife also willing to give the consent. In such a there is the Mubarak. This is under the personal law. And these mode divorce other offer can be made from the either of the sides, and acceptance of offer makes a divorce irrevocable. Yes, of course, either period is essentially. There's the 3 lunar months. Okay. Suppose if she is a menopause, I told you already 90 days or 3 lunar months, we will take it into consecutive. We will take it. Under Shia law, parties can dissolve their marriage if it is not possible for them to continue their marriage by way of Mubarak. Suppose if they say both lives are miserable, then better we will say, Shia law says, can dissolve their marriage if it is not possible for them to continue their marriage by way of vivara. The last mode mentioned in the above table of the dissolution of marriage is by way of judicial separation. Yes. Can anybody unmute and read what I put it on the judicial? Remember it? Judicial. Sorry. Dissolution of Muslim Marriage Act 1939. Yes. What is that?
Dissolution of sir. Gone, sir.
Yes. What is put it over there? There are two ways.
Sir, there are two ways. Lian can simply be described as the wrong charge of adultery on wife by her husband. Whenever a husband imposes false adultery charges on his wife, then a wife can sue him and can also obtain a divorce on the same ground under the act by filing a regular suit for dissolution of marriage. In case of Jafar Hussain versus Umat or Rahman, Allahabad High Court held that a wife under Muslim law is entitled to file a suit against her husband for dissolution of marriage and can obtain decree on the ground that she was falsely charged with adultery by him.
Yes. If the husband make a false charge against the wife, that you indulged in such a BBC, means having sexual intercourse with another man. At that instance, if it is proved that it is a false charge, then that is the ground for the wife to get the dissolution of marriage. Automatically, the dissolution of marriage will not take place. She has to file a suit for the dissolution of marriage in the court of law. So that is observed in the Zafar Hussain versus Ummatur Rahman. I repeat, Zafar Hussain versus Ummatur Rahman. Allahabad High Court held that a wife under the Muslim law is entitled to file a suit against her husband for a dissolution of the marriage and can obtain the decree on the ground that she was falsely charged with adultery by him. By him means by husband. So what are the essential things? Number one, yes. First bullet, can anyone unmute and read?
A husband must be adult and sane. He charges his wife of adultery. Such a charge must be false. False charge do not ipso facto, by that fact itself, dissolve the marriage. It just provides a ground to the wife to move to the court to dissolve the marriage. Marriage will continue until the decree for dissolution of marriage is passed by the court. Judicial separation via mode of lien is irrevocable. This mode is applicable only to Sahih marriages, not on fasid ones.
Yes, the mode is applicable only to Sahih marriage, means valid marriage, and not Fasid one. Fasid one means anyone? Void marriages. But illegal marriage is Fasid. Is it void marriage? There are three types of the marriages are there. One is Sahih marriage, another is Fasid marriage, another is Batil marriage. Batil is, which is voidable. So this type of the matter. Then we will see the retraction. What is retraction? Retraction can be made by the husband before the end of this trial, admitting that he made the charge of adultery against his wife and such charge was false. Suppose when the case is not filed, at the time he can make the retraction. No. What I said is false. If he made such a confirmation, that it's called retraction, can be made by the husband before the end of the trial. Before the end of the trial, admitting that he made a false charge of adultery against her wife, such a charge was false. Yes, he can make it out. No action will be taken against him because his retraction, which is confessing what I made is a false statement. That first, Quran says that the husband and wife are duty bound to respect each other and treat each other respectfully and obey the lawful orders of each other. In both of them find that they cannot live as a husband and wife further, they can approach Hazi and who after careful examination may terminate their marriage. Then this also a practice would be there better. That's why we can say extrajudicial remedy, extrajudicial the talaq, these are called. It is not done by the court, but a Hazi can sit over there and take the signatures, and we will see that the problem is solved regarding the first. Of course, such a first and other things are already put it over there in the section 2 of the Dissolution of Muslim Marriage Act 1939. And there are 9 grounds on the within the Muslim wife can obtain the decree of divorce under section 2 of the Dissolution of Muslim Marriage Act of 1939. Number 1, Absence of husband. How many days? 4 years absent. Dissolution of marriage decree on the ground will take effect after 6 months from the date of such decree is passed. Of course, after decree is passed over there, the duration period is 6 months. They have to wait it. Within the 6 months, if they heard that the husband is alive over there, then the decree will be cancelled. Failure to maintain. Suppose the husband failure to maintain the wife, both roti, kapda, makan, food, shelter, and clothes, and consecutive 2 years would be there. That's called desertion. At that instance, she will be file a case on the ground of desertion under the section and the failure to maintain. Then, if suppose the imprisonment of a husband, suppose the husband is imprisoned for the 7 years or more, then that is a good ground for the filing case for the dissolution of marriage. Then another ground, failure to perform the marital duties. Yes. What are the marital duties? Both physically, mentally, biologically, everything we do the duty to the wife. The husband is unable to perform such a duty would be there, obligation to be there for the 3 years, then automatically she is a good ground for the getting the decree of the under this section. Impotency of the husband. Yes, this is a very good ground from the day it is married until the file is cased. If it is proved that the husband is impotent, then that is a good ground. Then the another ground is insanity, leprosy, and venereal diseases. If the husband is insane or suffering from the leprosy, I put the leprosy in the red because in the personal law, that is the Personal Law Amendment Act of 2019, made amendment to the Dissolution of Muslim Marriage Act of 1939. In the Dissolution of the Muslim Marriage Act of 1939, in section 2, the ground 6, that is the sixth clause, the word leprosy or shall be omitted. So leprosy is not the ground for the getting the decree now. That's why I put it in leprosy. It is deleted over there. Or any other venereal diseases would be there for a period of 2 years. Either insane or suffering from any venereal diseases. At that instant, there is a good ground for the judicial divorce. Because now leprosy is a now curable disease like a cancer. Okay, that is the ground. Then repudiation of the marriage by wife. Suppose if a girl married before the age of the 15 years by her father or the guardian, then under the Muslim law, she has been provided with the right to repudiate the marriage after attaining the age of puberty, age of 18 years, provided the marriage is not consummated. Condition is the marriage is not consummated. At the time only she is having the repudiation with the marriage by wife. Suppose consummated, there is no such a chance. She is entitled to a degree of divorce at that time, no consummated. Ground for the dissolution recognized with Muhammad Allah. Wife is also entitled to obtain the divorce and the ground recognized with the valid under the law. Yes, even the husband or wife, both are there. The thing, how the wife can make it out? Cruelty by the husband. If the cruelty would be proved over there, there is a good ground where we can make it out. What is cruelty is stated clearly. The physical assault is the cruelty, and making a defamatory statement affecting her reputation is the cruelty, and forces her to lead an immoral life is a cruelty, obstructing her from practicing her religion is a cruelty, even not allowing her to go to his parents and relatives' house also a cruelty. Husband having more than one wife and does not treat them equally, also cruelty. Suppose the husband says something after marriage that I will give you a buy for this one, even he did not fulfill also. In one of the case law, one Zafar Hussain case law, I believe, they say it is a cruelty because the promise which he made before the marriage, he could not fulfill it after the marriage. That is also said to be a cruelty. They said in one of the case law. Of course, I have the case law, but in somewhere. Zafar Hassan versus Sultana case law. This Talakhnama means a book where it is written. What Talak is written is called Talakhnama. Like Vakalat. What is Vakalat? Anyone? Talakullah, you open it and you disappeared. You are not participating in my class. Talakullah, just you are present and you disappeared it. Okay, no matter. Is a talaknama is a talak given in the written form. The talaknama can be provided in the absence of wife, and there will be no necessity to be signed in the presence of the qazi or wife father. Then husband has to execute a proper deed, that is a book, a document. A deed must contain the name of the woman to whom he divorced and her name, and everything should be written over there. And a points to be considered for the valid talak. A talak pronounced under the intoxication. Suppose intoxication is talak is pronounced there and is not recognized valid under the Muslim law. For a valid talaq, intention is not an essential element. That's why the people try to use it in a different way. That is the reason that triple talaq is unconstitutional made in the Sahara Bano versus Human Affairs. Husband may give that talaq by mere words without any talaqnama or deed, and these are the things are there. And talaq made during the death illness is also valid, provided some conditions should be fulfilled over there. If the man pronounces the irrevocable talaq in death illness and dies before the expiry of the iddat period, the wife is entitled to claim her share. Because some people want to give at the time of the talaq so that they try to save from the inheritance. The property goes to the widow or the divorced wife. So what are the conditions should be there for such a thing? In case of the husband dies after the expiry of the iddat period, then there is no right of inheritance. After the expiry of the iddat period, there is no right of inheritance, and legal effects of divorce will automatically comes. Mutual rights of inheritance ceases automatically. Cohabitation becomes illegal, and children born after such intercourse will be illegitimate. Dower becomes immediately payable. Parties can contract another marriage once it is effected. And a wife is entitled to maintenance during the iddat period and beyond, based on the, of course, beyond also. We can say that whether the Shabana case, they say CRPC section 125, once the divorce is given over there, not only for the period, till her death or until she got second marriage, up to that extent, the maintenance should be given to the divorced wife under the section 125 of the CRPC. Yes, conclusion, can anyone read? Yes.
Conclusion, sir. After the 2017 judgment of the Supreme Court held and declared triple talaq unconstitutional under Muslim law, both husband and wife are given equal rights to dissolve their marital relationship. Yes, sir. Marital relationship. When two people enter into a marital relationship, they might not know each other so well as they got to know each other after living together. And after that, if there is no compatibility between the two, living apart is the best choice to made. Bad relations may spoil the life of both the individuals, and under Muslim law, talaq is an ancient practice and is not recognized as a sinful act, unlike under Hindu law.
Yes. So naturally there would be some solution would be there, because if compatibility would not be there both between the wife and husband, and life becoming miserable, at the time it becomes a difficult task for them. The best thing is they have to separate each other. If not, life becoming miserable. Then that is the last resort. That is the reason Talaqul Ahsan, AHSAN, where the Prophet said such a word one should not be supposed to take on their tongue. Which word? Talaq. That is the reason he said, in the 3 months' time, only first month you have to recite such a word, Talaq. The second month you are not supposed to recite, but you have to abstain from the consummation with the wife. Again, the third tuhur also, you have to abstain from the consummation with the wife. But once she goes to the menstrual cycle, or before that one, yes, it becomes irrevocable. Because in that period of the 3 months, that is 3 lunar months for the menstruating woman, and for the menopause woman, automatically 30, 90 days, 3 months will be taken together. Later it will be, no consummation would be there. Naturally it is deemed that, yes, it is deemed that it will not be made. Okay, that is the reason that you can make it out. Yes, and see, Muslim law, virtual classes in Muslim law, and I have taken last time also. And when the regular classes are going on, and the source of Muslim law, the YouTube link, you have it. Just you type the source of Muslim law, YouTube link, you will get it. Marriage under the Muslim law, my name, you write it and you will get the link. The parentage legitimacy, you write my name and write the parentage legitimacy, you will get it. The total parent and parentage and the legitimacy plus acknowledgement, you write my name, Mohammed Saheb Hussain, Then you give the space, parentage and legitimacy plus acknowledgement in the YouTube, then you will get it. Effect of conversion in Muslim law, you will get it. Then talaq or divorce under Muslim law 1, then talaq or divorce under Muslim law 2, you will find the two videos over there. And the dower 1 under the Muslim law, you will find the video. And the gift or hiba under the Muslim law, you will get the video. And because these are the links which I provided over there, and I will try to provide the same links to you in the WhatsApp group so that you can tap it, you can listen it, because time is short, and today is the third, and tomorrow is the fourth, and the fifth, and the sixth. In the sixth, in the morning, I will take the class, but the fourth, the same timings, I will take it 6:10 to 7 o'clock, and the fifth also same timings, 6:10 to 7 o'clock. But on the sixth, where the exam is there, I will take in the morning hours, but I will specify you in advance in which time that I am going to take it. So inheritance, awl and rod plus distinction between the Sunni and Shia law inheritance, I made it. Maintenance part 1, maintenance part 2, maintenance part 3. There is a YouTube watch, you can make it out. Inheritance, how the mother, daughter, sons, shares, consanguinity, uterine brothers, plus sisters, I made it. Online scholar topic of the Christian Marriage Act, what are the salient features are there, 1872, I made the YouTube link. So my YouTube link, there are many, they think that only the thing what you have to do is, you have to write my name first. Sir, how to write your name, sir? How to write your name? You don't know.
Professor Dr. Mohammed Saheb Hussain.
Not necessarily that much you can write it. You can write it in this way also, it's enough. Just I'm showing over here. Mohammed Mohammed Saheb Hussain, you write, then give the space, YouTube, you write, and you will get all the things. Suppose you want to more specifically, in search you can type it. Suppose if you want to get a divorce, in search you can type it divorce, like that, you will get it automatically. See, I will show you also that, how you get it. See, YouTube,
Okay, sir.
I will take it, this YouTube, I take it. I'm go to the Google search engine and copy. I'm going to the Google search engine now. Then, see, already
Yes, sir.
you got it, something. See, you already got Annidanam kana Vidyadanam in all arms education arm is good. See, here you can type it. Here, search is there. Here you can type it. In search, you type here. Suppose you want school of law, that is schools. Schools of Muslim law, for instance. So just use a search. See, application of Muslim law, conversion to Islam, the effect of conversion, difference between Shia and Sunni, and all that which is connected to it. Talaq, parentage, and public international law, brushing, and the law set ASP, everything that you will get it, but you can search it. What you need it. What you need it, you have to search it. Then automatically you will get the things. So that is the way that you can go and take it and type it. So directly I made it, but I will show you also. I will show you also the way that you can make it here. I see there are all my suppose it is a YouTube. Okay. Now I made that my name and YouTube. Okay, paste. Then I made it. See, Mohammed Saheb Hussain YouTube. See,
Yeah.
you get,
Yes, sir.
you see how many are there, one after another, you will get it. See, this is the way we can make it out.